Hey everybody, my name is Rebecca Simone. I'm your favorite consumer law advocate, consumer law consultant, and I'm here to teach you guys something today. I just want to answer a question. So I'm going to try to answer more questions because I see a lot of y'all ask a lot of questions under my videos. I'm not really on YouTube a lot. However, I will be dedicating more time to this channel since I see it's picking up. If you guys can do me a favor and share this with somebody, that would be great. Also, if you're viewing this from Instagram, TikTok, Facebook, go and follow me on YouTube, Rebecca Simone. All right, the question says, first of all, I love your channel. It says in the contract how they may assign or transfer the account to whomever, and we sign for this. So how exactly are they violating us if we gave them permission to do so? Is it because they don't disclose what comes after all of that? Them selling a security to investors, monetizing and trading it? And were they supposed to tell us they are paying us our dividends each month? Or is that on us because we should have known what we were getting ourselves into before signing? Or could it be them stating in the contract that they loaned us money when they didn't loan us anything? They extended us credit. Great question. It says just shy. All right, so I'm going to respond to this, right? First of all, thanks for the compliment. Love you too. Secondly, the contract may say that they can transfer or assign it to anybody else. However, just because you signed it does not mean that the contract met all of the elements that it needed to meet to be valid. So let's just say you sign a contract that says they could transfer it, but somewhere else in that contract there is fraud, right? So fraud would void the entire contract, meaning that even if you signed it, if some type of fraud was committed throughout the contract, then it's now invalid, okay? And a lot of companies try to use the fact that, oh, you signed the contract to say that now you legitimately have to pay it. But if a contract does not make the law, and if the contract violates the law, then it's void. Listen to this. So the book reference is American Jurisprudence, book number 17. It says a contract is not law, nor does it make the law. It is an agreement plus the law that makes an ordinary contract an enforceable obligation. Okay? So your contract has to meet all the elements of the law for it to be enforceable. Oh, first of all, let's talk about your contract being unilateral. So she made a statement about them saying they loaned us money. So in your promissory note, right, it never says anything about what the company plans on doing. It only says what you plan on giving them. So a contract is unilateral when one party who makes a promise has received a consideration other than a promise to make the contract binding. A unilateral contract is also defined as one in which there is a promise on one side only, the consideration therefore being an act or being executed. Typical of this class are promissory notes. The term unilateral has also been used to describe what is sometimes denominated as a contract, but which in reality is merely an offer to contract. For example, a promise to pay one for services if he should perform them, the latter being under no obligation to perform such services. An agreement by the payee of a note that if the makers would pay interest thereon at a certain stipulated rate until the death of the payee, the note should be discharged, has been called a unilateral agreement as well. So then I would ask myself, where did it say on the contract? I mean, saying for a loan received, where are the terms of that loan? Because you can't just say, because I gave you this, you have to do that. Where are the terms of that transaction? These are the terms of this transaction. What are the terms of the previous? How do I even know you gave me money? I never saw it. I didn't see a wire transfer. I received goods, which means I sold you my security, the contract, in exchange for the goods. You purchased the goods by giving me the property for the contract. You took the contract, you over collateralized it, which is a breach of truth in lending. So let's hop over there. If you have not been to my pin site to get a copy of this, y'all disregard this. Get a copy of Truth in Lending Act. I'm gonna read to y'all the purpose of this. So Congress wrote this to protect you guys as it pertains to extending your credit. It says, the Congress finds that economic stabilization will be enhanced and the competition among various financial institutions and other firms engaged in the extension of consumer credit would be strengthened by the informed use of credit. The informed use of credit results from an awareness of the cost thereof by consumers. You cannot know if you are paying a decent or a fair price for your credit being extended if you don't understand the ins and outs of how much is really being made off of it, right? So if I'm going to pay at a fixed rate this amount of money, but you're going to take initially my promissory note and over collateralize it, I would never agree to that. That means they were misleading you. So it's deceptive, it's unfair if they do things outside of what they approved or what you approved for them to do. This goes on to say, it is the purpose of this subchapter to assure a meaningful disclosure of credit terms so that the consumer will be able to compare more readily the various credit terms available to him and avoid the uninformed use of credit, and to protect the consumer against inaccurate and unfair credit billing and credit card practices. The Congress also finds that there has been a recent trend toward leasing automobiles and other durable goods for consumers as an alternative to installment credit sales, and that these leases have been offered without adequate cost disclosures. Let's talk about the right to rescission. So, the right to rescission, I'm reading from 15 U.S.C. 1635. The right to rescind certain transactions. So, these are disclosures of the obligor's right to rescind. The creditor shall clearly and conspicuously disclose. Clear and conspicuous means that I should not have to figure out, read and see in here where this is. It should be big as day. It should be a separate sheet of paper. I should have had to acknowledge this separately to say, hey, look, you have the right to rescind. If you have a contract that says no cooling off period, you don't have a right to rescind. If you have a contract that says, as is, they're implying that you don't have a right to rescind. However, the law, federal law, says you do have a right to rescind. With that being said, that's misrepresentation for them to have on your contract. That's another reason why, it's illegal for them to do what they're doing. Not so much so as they have to walk you through the ins and out of everything, but you cannot purposely mislead me. Misleading me is having me sign an agreement that would put you at a much greater advantage than it would me financially when you are doing all of this off of my back. All right, listen to this. The creditor shall clearly and conspicuously disclose, in accordance with the regulations of the Bureau, to any obligor in a transaction subject to this section, the rights of the obligor under this section. The creditor shall also provide. So not only is the creditor supposed to notify you of your rights, so you should have known about this. The creditor shall also provide, in accordance with the regulations of the Bureau, appropriate forms for the obligor to exercise his right to rescind any transaction subject to this chapter. The mere fact that they didn't give you that disclosure means that they violated this law, which means that the contract is not valid. Why? Because it does not comply with federal or state law. So if your contract breaks the law, remember what I said. A contract is not the law, nor does it make the law. It is an agreement plus the law that makes the ordinary contract an enforceable obligation. So that law was broken, meaning that contract is not an enforceable obligation. The end.